everyone, this is part 2 of our reading from this lovely book about the Magna Carta. We chose the Bishop's Palace in Wells because there's so many beautiful places here to stand and read, and it's quite a long chapter, so this is part 2. We did the lead up to the signing of the Great Charter, well, the sealing of the Great Charter, and we're going to do another chapter here in this garden. Wells is a very historical place. The Monmouth Rebellion has a lot to do with Wells, and the last, I can never remember this word, pitched battle in England was in Wells, the bloody Battle of the Assizes, and that was relating to our Catholic King James II. And I think the last time the Magna Carta was used was like just before the Great Revolution in 1688, so that is around that time. 1686 was the bloody Battle of the Assizes, and it took place here. So I'll just carry on with my reading of the Magna Carta here. Right, the Great Charter, although drawn up in the form of a royal grant, was really a treaty between the king and his subjects. It was framed upon a series of articles drawn up by them. It contained the provision usual in treaties for securing its execution, and although in express terms it contained only one part of the covenant, it implied in its whole tenor the existence and recognition of the other. The king granted these privileges on the understanding that he was to retain the allegiance of the nation. It is the collective people who really form the other high contracting party in the great capitulation. The three estates of the realm, not, it is true, arranged in order according to their profession or rank, but not the less certainly combined in one national purpose, and securing by one bond the interests and rights of each other severally and of all together. The Charter contains a clause similar to that by which Henry I tried to secure the rights of his subjects as against the messy lords, but now the provision is adopted by the lords themselves for the security of fair and equal justice. So it includes the whole of the people, it says here. All the aforesaid customs and liberties that we have granted to be held in our kingdom, so far as pertains to us, with reference to our vassals, all men of our kingdom, as well as clerk, shall observe, so far as pertains to them, with reference to their men. The barons maintain and secure the right of the whole people, as against themselves as well as against their master. Clause by clause, the rights of the commons are provided for, as well as the rights of the nobles. The interest of the freeholder is everywhere coupled with that of the barons and knights. The stock of the merchant and the wainage of the villain are preserved from undue severity of amercement, as well as the settled estate of the earldom or barony. The knight is protected against the compulsory exaction of his services, and the horse and cart of the freeman against the irregular requisition even of the sheriff. In every case in which the privilege of the simple freeman is not secured by the provision that primarily affects the knight or baron, a supplementary clause is added to define and protect his right, and the whole advantage is obtained for him by the comprehensive article which closes the essential part of the Charter. This proves, if any proof were wanted, that the demands of the barons were no selfish exaction of privilege for themselves. It proves with scarcely less certainty that the people for whom they acted were on their side. The nation in general, the people of the towns and villages, the commons of later days, the Englishmen who had fought the battles of the Norman kings against the feudatories, had now thrown themselves on the side of the barons. John's tyranny had overthrown that balance of the powers of the state which his predecessors had striven with so much earnestness and so much policy to adjust. We do not indeed find in the list of those who forced the king to yield any names that prove the commons to have been influential in the drawing up of the articles. The conspicuous names are those of the northern barons, of the men of the great ministerial houses, and of that remnant of the conqueror's baronage that had cut themselves loose from Normandy and Norman principles and reconciled themselves to the nobler position of leaders of their brother Englishmen. It was probably by the bishops Langton in particular, and the legal members of the Confederacy, that the rights of the freeholder were so carefully fenced round with provisions. These men and their successors led the Commons and acted for them until the Reformation, with little discord and still little jealousy of their rising influence, and it was the extinction of the class which furnished their natural leaders that threw the Church and the nation under the tyranny that followed the Wars of the Roses. The Great Charter is the first great public act of the nation. After it has realised its own identity, the consummation of the work for which unconsciously kings, prelates and lawyers have been labouring for a century. There is not a word in it that recalls the distinctions of race and blood, or that maintains the differences of English and Norman law. It is in one view the summing up of a period of national life, in another the starting point of a new period, not less eventful than that which it closes.